Good morning and welcome to the webinar on Closing Loopholes Number 2 Amendment Act and the Road Transport Industry. My name is Michelle and I'll be your webinar moderator. Today you will hear from Gillian Bristow, Bristow Legal. Gillian has been involved with the Australian heavy vehicle industry for 30 years. The industry focus of her practice gives an appreciation for the specific legal and compliance issues facing transport and warehouse operators. Recent amendments to the Fair Work Act means big shifts for the road transport industry. Today's webinar will give you the ins and outs of the new laws, including the new definition of employee, new bodies such as the expert panel and the various orders they can make, and protections from unfair termination and unfair contracts. Gillian will explain how to navigate these complicated changes and keep up to date with the legal requirements. Like always, we'd love to hear from you during today's presentation. If you have a question, please feel free to type it in the Q&A section at the bottom of your screen. Questions will be answered at the end of the session. Today's webinar will be recorded and uploaded to the NatRoad website and YouTube channel. So welcome, Gillian. Over to you.
Thank you so much, Michelle. It's lovely to be with everybody today. I've got an awful lot of material to go through with you today, and the entire closing loopholes legislation that has been introduced recently by the federal government is probably the biggest shake-up of industrial relations in Australia in a decade or so. What we're going to be looking at today is very much those parts of the legislation that specifically affect the road transport industry. So even though we're going to be going through a lot, I want you to understand that there's other stuff out there that you need to know about. For example, there are provisions in the closing loopholes legislation that deal with things like engagement of casuals, that deal with union rights of entry, that deal with right to disconnect. We're not going to be talking about any of those today because they basically affect everyone who employs people in Australia. Now, there are a lot of resources already on this topic generally on the NatRoad website that are available to members, and I would encourage you to have a look at those. I'd also encourage you to have a look at the Fair Work Ombudsman's website because there's an awful lot of extra explanatory material about both those other changes and about what we're going to be talking about today. Now, this looks like a lot to be getting through today, but essentially what we're going to be talking about is the who, what, when, where, why, and how of these new changes and how they're likely to affect the way road transport businesses operate in Australia. And I'm going to talk you through these one at a time as we go through today's session. But what I want you to realise to start with is that this legislation has lots and lots of terminology in it. And sometimes it's not a bad idea to have a slide like this as you're running through the legislation, just because sometimes the jargon itself gets in the way of understanding. Now, I'm going to be talking about a lot of new groups and a lot of new ideas about what we call things today. The one that I'm probably going to be talking about the most is the last one on this particular slide, and that's this idea of a regulated road transport contractor. Now, that's a lot of words, but if every time I say that you think owner-driver, you will be on the right track. So essentially, this legislation is taking something that you and I would understand as to be an owner-driver and putting in place an awful lot of protections for that class of person. Now, I'm going to start with the why today because it's hard to understand a lot of this legislation without understanding what the government's program is and what they're trying to achieve here. For decades, it's been the policy of the Labor Party that owner-drivers should be regulated and that there should be minimum standards in the transport industry. What I've got on this particular slide is an extract from a speech made by the then Minister for Employment and Workplace Relations, Tony Burke, about this idea. So the principle behind all of this is that the road transport industry would be safer if we had more protections in terms of what people are paid, especially in that owner-driver space. So what they're trying to do here is to make sure that there aren't rates pressures and there aren't time pressures imposed on owner-drivers that then contribute to safety issues on our roads. The next idea behind a lot of these provisions is, as set out again from a Tony Burke speech, is that the idea that Australia's workplace relations system before these changes very much distinguishes between an employee who has lots and lots of rights, including to be protected from unfair termination, to be entitled to annual leave, to be entitled to bargain for wage increases, etc. And then the idea that as soon as you're a contractor, all of that stops. You're on your own. You're not protected at all. And he calls that the distinction between being an employee and then having your rights fall off a cliff the moment that it's determined that you're a contractor. So the purpose behind some of these amendments was to stop there being a loophole and turn that cliff between being an employee, dropping off the cliff, and being a contractor into a ramp, so that contractors get a bunch of the same protections that employees currently have. So thinking about all of that, we're now going to talk about how this legislation changes things if you're operating a transport business. In terms of the when, this legislation was passed earlier in the year, and it commenced on the 26th of August 2024. So that means all of it started now. But as we go through, you'll see that practically speaking, there is a time delay simply because, for example, it takes a while for orders to be made under this legislation. And in the sense as well that it only applies in some situations to contracts that are entered into after this legislation was commenced. But I'll go through that in the course of today's presentation. So now we've worked out the why and mostly the when, we're going to talk about what is in this particular legislation. Now, I'm going to spend a few minutes now talking about what is actually a really important issue in practice. And that is, how do we decide if someone is a contractor or if someone is an employee? This is actually a really important distinction in practice, because you'll know, running a business, that employees have a lot of specific rights, like the right to be paid wages and overtime, the right to annual leave and long service leave, and the right to particular protections if they're going to be dismissed. So it's important to be able to distinguish between a contractor and an employee. And this has always been a tricky thing to work out. There was a very important High Court case back in 2022 that dealt with how you decide if someone who, to all extents and purposes, is an owner-driver might be an employee. Now, this particular case, you've probably heard of it, but I'll just briefly go through the facts. So it was about two drivers who worked in the same depot pretty much the whole of their working life. They originally started out being drivers, but then their employer said to them, listen, we want you to buy these trucks. If you want to continue on with us, you've got to become owner drivers. They bought the vehicles for quite significant amounts of money if you consider this was in the late 80s, early 90s. They formed partnerships, so they were no longer sole traders, and they continued to work for this particular business pretty much non-stop until retirement. They wore uniforms, their vehicles were sign-written, they controlled the loading of their vehicles. There was nothing to stop them working for other people other than this particular business, but they didn't. Pretty much apart from one occasion, they didn't have other people drive their vehicles. The issue was, after the event, these particular drivers came back and said, hey, we think we're employees and we're entitled to all of the rights of employees across that long period we worked for you. There was a full federal court case that said they were right, that they were in fact employees because they had so little control over the work they did. And aside from supplying their vehicles, an awful lot of what they did looked awfully like being employees because of the extent to which they were controlled. The High Court was then asked to hear an appeal of that decision, and they handed down a really important decision. That decision was essentially that those particular drivers were not employees, that in fact, the starting point was to look at their written contract. And as long as there was no good reason for going away from that written contract, you looked at that. If the contract said they were contractors and pretty much everything stacked up along those lines, then they were contractors. End of story. No need to go and look at how the contract was performed in practice, whether they ever worked for anyone else, the extent to which they could have or should have or did display sign writing, etc. Start with the contract, look at that. It's likely to determine the question. That made things pretty straightforward. It meant that transport operators could basically determine the issue of whether someone was an owner-driver or an employee early on by having an appropriate written contract that spelled out the nature of the relationship. That would then remove all the need to look at the way the contract was performed and all of those other factors. What this legislation does is it turns back the clock. It says we're not going to deal with employment questions versus contractor questions in that way. We're going to go back to what the law looked like before that High Court decision. So we aren't going to just look at the terms of the contract. We're going to look at the totality of the relationship, including how the contract is performed in practice. And what we're going to be looking at in deciding if someone's an employee or a contractor is the real substance, practical reality, and true nature of the relationship. So what that means in practice is it's no longer that easy to determine whether someone who's an owner-driver, even if they're supplying their own vehicle, is a contractor or an employee or not. There is a provision in the new legislation that says that if someone who is earning more than $175,000 can actually effectively nominate to say that they want to be a contractor. But there are some complexities around that I'm not going to discuss for the purpose of today. Now, having regard to the legislation and winding back this High Court decision, we need to look at a lot of different issues in order to determine whether someone is actually a contractor or is actually an employee. On the screen here are some factors that would point to someone being a contractor, supplying own tools or vehicles, especially expensive ones. But remember that in that Jamset case, a court found that even supplying a vehicle wasn't enough to make these guys contractors. Having control, being free to work for others, bearing the risk of loss and being responsible for any failures in the services, presenting as your own business as opposed to the business of somebody else, so having your own uniforms, your own paperwork, the fact that you can build goodwill, the fact that you're being paid for results and not for time spent, plus also what's in the contract. Now, as I said earlier, this idea of whether someone's a contractor or whether they're an employee is really important because of what flows from it. So if an owner-driver were found to be an employee, they could be entitled to long service leave, redundancy payments, etc. So it's really important that you consider the relationships you have with people that you consider to be contractors as a result of these changes to the law. Now, even if we get to the point where someone is working for you and they are actually a contractor, and probably an owner-driver in the sense I'm going to discuss next, that they are likely to be regulated by this new legislation. That's because these new laws regulate what you and I would call owner-drivers, but they're called regulated road transport contractors. And we're going to move on now to talk about this particular concept and how the legislation effectively introduces a new regime for how relationships with regulated road transport contractors, also known as owner-drivers, will be managed. This is an incredibly complicated definition that appears in the legislation of what a regulated road transport contractor is. Now, you'll see, this is a straight extract from the legislation, that what's important here is that a regulated road transport contractor is going to be an individual, but it can also pick up individuals where the contracting entity is actually a company, because you'll see from number 2, if a company, in other words, a Pty Ltd entity, is a party to a services contract, then someone who's either a director or a member of a family of that director who performs work under the contract could be a regulated road transport contractor. A similar principle applies if you're engaging a trust or if there's a partnership. If there's an individual who performs work under that contract, then they could theoretically be a regulated road transport contractor for the purpose of these new laws. Now, to be a regulated road transport contractor, you've either got to be an individual performing work or an individual associated with a company or a trust or a partnership performing work. But you've also got to be performing all or a significant majority of that work and not as an employee. Now, the point of this is to make sure that this definition only captures small businesses. So, for example, if you've got a company that's performing work under a particular contract and it's got a whole bunch of employees, then obviously no one person is going to be performing all or a significant majority of the work. So they will then stop being a regulated road transport contractor. So the point of this is to try and effectively regulate owner-drivers, small businesses performing work in the road transport industry. The last point on this slide about the person must not be an employee-like worker, that's because there's also provisions under this legislation that deal with gig workers. And this is mostly the kind of Uber space where you've got someone who's performing digital platform work in the transport industry. Now, I know all of that's really complicated, but even if we wind it back again and say it's likely that if someone in your mind is an owner-driver, they're probably a regulated road transport contractor for the purpose of these provisions. And if you're not sure, you should absolutely get some specific advice about that. So now that we've worked out who a regulated road transport contractor is, I'm going to talk about who are the new players in this game in the Fair Work Commission who are going to be making orders and rules about how in the transport industry we manage regulated road transport contractors. There is a new expert panel that's been created in the Fair Work Commission. And the purpose of this panel is to make modern awards that relate to the road transport industry. So in other words, they've got powers to be able to make and amend the existing awards that deal with the transport industry. That expert panel also has the power to make, vary, or revoke road transport minimum standards orders and road transport guidelines. And I'm going to be talking in a bit more detail in a few minutes about what those are. In exercising these powers and making these particular orders, the expert panel has to consider the road transport objective. And the road transport objective is, as set out in this panel, on this next slide, is taking into account the need for minimum standards and a safety net, but avoiding issues with business viability and administrative and compliance costs, and avoiding adverse impacts on the national economy. But always remembering that the idea is they're going to set standards to ensure a safe transport industry. Now, that particular panel is then assisted under the law by the Road Transport Advisory Group. The intention here is that industry is consulted and the special features of the road transport industry are taken into account here. So the Road Transport Advisory Group is appointed by the minister, and they have to be members of particular organisations, and their purpose is to provide advice to that expert panel on what should and shouldn't be in either minimum standards orders or in modern awards. They also have to establish a subcommittee with a majority of owner drivers if a particular order that's proposed is going to potentially affect owner drivers. The next slide just shows you who is currently on the Road Transport Advisory Group from the date that this legislation commenced in August. Now that we know who we're talking about, in other words, we're talking about regulated road transport contractors, and we're talking about the Fair Work Commission and their expert panel, I want to talk about what. What is it that this particular legislation is going to do, and what sort of orders and guidelines can potentially be made? So the two sorts of orders that this new panel of the Fair Work Commission can make are road transport minimum standards orders and contractual chain orders. I'm going to break those down and explain them in a little bit more detail. So a road transport minimum standards order is an order that applies to your relationships with regulated road transport businesses. So remember, we were talking about before what I would call owner-drivers. These will be orders that set out minimum engagement terms for when you engage. And again, I'm going to use simpler terminology, an owner-driver. Now, those of you who were around about a decade ago will remember that we had a tribunal that effectively could do something very similar to this. So this is something akin to an award that would apply to an employee, but this time it's an order and it applies to regulated road transport contractors. Now, these orders must include terms that set out what sort of work is covered, what sort of regulated road transport contractors will be covered by the order, and what sort of road transport businesses will be covered by the order. The order doesn't have to, include provisions about payment terms. In other words, for example, you must pay owner-drivers within 14 days, working time, deductions, so what amounts can and cannot be deducted from payments due to owner-drivers, record keeping, insurance, consultation, cost recovery, delegates' rights, etc. One of these orders cannot include terms about overtime, rostering, matters of a primarily commercial nature, cannot include terms that would change someone from being an employee to being an owner-driver or vice versa, cannot deal with workplace health and safety that's otherwise comprehensively dealt with elsewhere. So, for example, if something's already regulated under the heavy vehicle national law, we can't have something contradictory in one of these road transport minimum standards orders. Now, it's not mentioned in either of those two slides, but absolutely one of these minimum standards orders could include payments. So in other words, it could set minimum rates that you have to pay an owner-driver. However, the law makes it clear that the Fair Work Commission must not make an order unless it's satisfied that doing so will not unduly affect the viability and competitiveness of owner-drivers. And as I said before, part of the process here is that if a particular proposed order is going to affect owner-drivers, then there must be a subcommittee of that advisory group. In addition, if there's going to be minimum rates, the Fair Work Commission has to consider the actual commercial practices that apply with respect to part load, mixed loads, no loads, multi-leg and return trips. This is a bit of a hangover from the previous provisions that we had in legislation about 10 years ago, where there was a lot of controversy around the setting of minimum rates and owner-drivers complaining that they didn't properly reflect what actually happens in practice, especially with backloads. Now, in the regulations, there are some parts of the transport industry that have been exempted. The area that is exempted under the regulations is livestock transport. And this is as a result of a compromise that was reached with the Senate in order to get this particular legislation through. So we can't have orders that deal with the transport of livestock. And just to show you how quickly these provisions have swung into action, 2 days after this legislation commenced, the Transport Workers Union applied for 3 different types of 3 new orders under these new provisions. You'll see that the numbers on the screen there, and you can follow these on the Fair Work Commission's website, because those particular applications have already been filed. And so you'll see on the bottom part of this slide where it says MS 2024-2, that application for a road transport minimum standards order deals with regulated road transport contractors, so again, owner drivers, providing last mile deliveries. And in terms of what the union wants, there's a whole heap of provisions that they've said they would like to see included in this particular road transport order that they want. And that includes superannuation contributions, blue card training, 4 weeks worth of annual leave, rest breaks, written notice of any terminations, and consultation about major workplace change. So those applications have already started. Now, I said to you that even though this legislation started on the 26th of August, it would take a while for us to see the effects. While the Fair Work Commission has power to make these orders regulating owner drivers, it's quite the process for those orders to be made. So as I said, the TWU has filed an application, but I'm now going to step you through what has to happen before one of those orders becomes law. So the first thing is an application's made by one of those parties on the screen. And you can see we've had applications made by the Transport Workers Union. Alternatively, the Fair Work Commission can also make an order on its own initiative. So that's step 1. And as I said, we're already in that step because of the applications that have been filed. The next thing that has to happen is there has to be genuine engagement with the parties that would be covered by this proposed order. The Road Transport Advisory Group has to be consulted, and that process is already underway. And then even after everyone's been consulted about the proposed terms of any order, there's a further consultation process where the Fair Work Commission has to publish a notice of intent. They've got to publish a draft of the proposed order, and they've got to give affected people a reasonable opportunity to make written submissions. They can also hold hearings about draft orders and then make a decision based on all of that to either bring into effect the proposed order or some variation of that. Finally, if they're satisfied that the order is good and that they want to make it, then they go ahead and make the order. But the general rule is that that new order can't come into operation until 12 months after the relevant notice of intent was published, unless it's urgent, in which case the order can come into operation in 6 months. So you can kind of get the feel from all of that, that even though we've had applications for orders lodged already, you're probably looking at 18 months before they come into effect by the time you allow for the order to be consulted about, to be made, and then that time period before it commences. So as a general guide, you wouldn't expect to see any orders actually in place and operational until probably January 2026. Now, it stands to reason that if you breach an order, there are consequences. The next slide I've got up here is simply showing you that if there's an order in place that regulates how you engage with an owner-driver, then there are civil penalties that can apply if you breach those particular provisions. Now, there is another form of order that the Fair Work Commission can make. This is much more far-reaching, and it deals with everyone in a contractual chain. So the Fair Work Commission can actually make what are called contractual chain orders. These don't just affect owner-drivers, they affect everyone from the person at the top of the chain all the way down to owner-drivers that are performing work that might be 2 or 3 tiers down in the contracting chain. Again, like the orders I was talking about that affect regulated road transport contractors, there are provisions that say what can and can't be in the order. So a contractual chain order has to say what work's covered, how it's going to interact with any other orders that deal with owner-drivers. It's got to have a dispute settlement procedure in it, and it can include provisions about payment terms, fuel levies, rate reviews, termination, and cost recovery. Again, like the orders that apply to regulated road transport contractors or owner-drivers, it can't include terms about overtime, rostering, changing the form of engagement, or other areas that are already dealt with by existing laws like the Heavy Vehicle National Law. And again, we've already started down this process of the Fair Work Commission potentially making contractual chain orders. On the 26th of September, the Transport Workers Union filed an application for a road transport contractual chain order. And this is basically to cover everyone or most businesses in the transport industry in Australia that are involved in transporting goods, wares, merchandise, etc. by road. Now, what is being sought in this particular contractual chain order is minimum payment terms that parties in the chain are entitled to rate reviews and entitled to fuel levies, and also provisions about preventing set-off of payments. So it's interesting. You can see that some of those things are, I guess, issues that the transport industry has asked for years in terms of its contracts with big customers. So it will be interesting to see what comes of this. Watch this space. And again, if you go onto the Fair Work Commission webpage, you can actually subscribe for alerts so that you can see what's happening with these particular sorts of applications. Same idea, if you breach a contractual chain order, there are penalties that are associated with that. Now, we've talked about orders that can be made that affect owner-drivers, orders that can be made to affect everyone in the contractual chain. In addition to that, the Fair Work Commission also now has powers to make guidelines. So a guideline is pretty much the same as an order in that it sets out various provisions, but in a guideline, it's not compulsory. So it's essentially a statement of best practice in terms of how you have relationships with owner-drivers or have relationships in a contractual chain. Now, the next slide is a bit busy, but anyone who's been in the industry for years always wants to know, how is this different to the legislation we had about 10 years ago that set up the Road Safety Remuneration Tribunal? So what I've done on this particular slide is just show you how this is different, because some bits of it are the same. So we've now got a body that can make orders that affect owner-drivers, that affect and that can potentially set rates. The major differences between these new laws and what we had with the Road Safety Remuneration Tribunal is there is a lot more consultation that has to go on here than had to go on under the previous legislation. There's a greater ability to vary orders, to suspend orders, and to defer orders once they're made. And plus, this whole idea of being able to regulate the contractual chain as a whole, not just owner-drivers, is new. That wasn't something that the Road Safety Remuneration Tribunal could do. So that's the end of the what in terms of the Fair Work Commission and what it can do with respect to making orders for the contractual chain and for owner-drivers. There's other parts of this legislation that affect relationships with owner-drivers as well, and that's what I'm going to move on to next. Now, very briefly, the new provisions give registered road transport contractors, in other words, owner-drivers, the ability to collectively bargain in the same way as employees. So they'll be able to effectively negotiate with principal contractors to agree on terms that will apply to particular work. If there is a collective agreement that's been made, then again, it's a breach if you contravene the terms of that particular collective agreement. The next area that the legislation affects is unfair termination and unfair contracts with owner-drivers. Now, this kind of harks back to the slide that I put up earlier on about this idea of, instead of dropping off a cliff once you stop being an employee, that there's a ramp. So what we're doing here is we're giving contractors some of the rights that employees have. So we're having the ramp instead of the cliff. What this legislation does is it protects some contractors from unfair termination. So the legislation says that a regulated road transport contractor, again, think owner-driver, who has been performing work under a services contract or a series of services contracts for a road transport business for at least 6 months is protected from unfair termination as long as they earn less than the threshold. At the moment, the threshold is $175,000 a year. So termination occurs if the services contract is terminated by or as a result of the conduct of the road transport business. Now, I said early on that this legislation commenced on the 26th of August 2024. You can't bring an action for unfair termination until 6 months after that. That's because the 6 months of service that you need in order to qualify only starts to run on the 26th of August 2024. So once we get to February next year, then an owner-driver who's got 6 months service post 26 August will be able to bring an action for unfair termination. It's quite possible that that limit of $175,000 that was only set recently will be increased at some point. That's because the federal minister has recognised that that number is probably on the low side in a transport context, because if you think about supplying a heavy vehicle and revenue generated as a result, it's highly likely that an owner-driver, for example, supplying a prime mover and a trailer, is going to earn from the provision of that trailer plus labour more than $175,000 in a year. So watch this space, because it's likely that that threshold will be increased as it applies to regulated road transport contractors. So what does it mean to unfairly terminate an owner-driver or a regulated road transport contractor? What the Fair Work Commission will be looking at is whether any dismissal is consistent with the Road Transport Industry Termination Code. Now, we don't actually know what's going to be in that code yet. It's an issue that's being consulted about by the department at the moment, but the idea is that the code is going to set out what sorts of reasons might be valid, what sorts of rights of responses owner-drivers should have if a principal is considering terminating them, and any communications that need to be made in order for a termination to be fair. That code will obviously have to be in place before that 6-month period from 26th August 2024 comes into play, because principals looking to terminate owner-drivers will need to have access to that code. Now, if you wrongly terminate the engagement of a regulated road transport contractor, there will be consequences. The Fair Work Commission has power to order that either the contract's reinstated, in other words, you need to re-engage that regulated road transport contractor, or that you pay compensation. And even if the principal no longer exists, an associated entity can be ordered to enter into a contract with that owner-driver who's to be reinstated. Any order that the Fair Work Commission makes for unfair termination can include lost pay, but compensation is capped at half of the contractor high income threshold and is based on pretty much what that owner-driver would have earned in the 26 weeks before they were terminated. And as you're looking at this, I'm sure that you can see that this is basically giving owner-drivers very similar rights to what an employee would have in terms of unfair termination. So again, moving from the cliff idea to the ramp. So owner-drivers being protected from unfair termination. The Fair Work Commission is also going to have powers to deal with unfair contract terms. Regulated road transport contractors will be protected from unfair contract terms in their contracts with principals. Again, these protections are only going to apply to someone whose income is under the high income threshold, which, as I've said, is $175,000 per year, but it's likely that that is going to be increased. Now, what would be an unfair term in an owner-driver contract? What the Fair Work Commission can do is it can look at the bargaining power of the parties. They can see whether there's a significant imbalance between the parties in the contract, whether the total payment the contractor's getting is less than what they would get under one of those minimum standards orders, which, as I say, we don't have yet, but we're likely to get. They can look at whether that term is reasonably necessary to protect the legitimate interests of the party, and whether that term is either harsh, unjust, or unreasonable. If the Fair Work Commission considers that a contract is unfair, they can actually make an order, either setting aside the contract, so saying we're not having that contract's not permitted to be in place, or amending or varying the services contract. Now, again, these provisions have already started, but they only apply to contracts that were entered into after the legislation started. So in other words, these provisions only apply to contracts with owner-drivers that were entered into after the 26th of August this year. Now, if this isn't already a lot for you to take in, there's some extra things that you need to bear in mind when thinking about these new laws. The first thing is there is already legislation in place that deals with unfair contract terms for owner-drivers. So even if somebody doesn't fall within these new provisions because either the contract was entered into before the 26th of August or because they earn over $175,000 in a year, there are still legislative provisions in Australia that allow independent contractors to apply to a court to set aside the contract or vary the contract. It's just you can't do that in the Fair Work Commission. You have to do it through other courts. The other important thing to bear in mind is that these new laws are not the only laws that you have to comply with if you're engaging owner-drivers. They don't override any of the existing state regimes that apply to owner-drivers. What they do is they're over the top of those provisions. So you have to comply with both. In other words, for example, if you engage an owner-driver in Western Australia, there is legislation and a code of conduct that applies there. If there's a provision that, for example, says you've got to give 3 months' notice to an owner-driver in Western Australia, but there's also a minimum standards order that says you have to give 1 month's notice, then you will need to give 3 months' notice. You don't get to just look at this new legislation. You still have to bear in mind that existing legislation and potentially how it applies as well. And from my point of view, I think that's a little bit unfortunate because it was already complicated enough under the state regimes, but now we've got this extra layer of complexity that is introduced by these new laws. It's really important that you understand that you need to comply with both. The one protection that the new legislation has built in is that an owner-driver can't make multiple applications. For example, if you're a Western Australian owner-driver, you can't bring an action under these new laws for unfair termination and then also go back and bring a similar action under the Western Australian legislation. You have to pick one or the other. So in that way, principals are protected from having to deal with multiple different bodies making rulings about, for example, unfair termination. And just as a reminder for anyone that's not familiar with it, we have got existing owner-driver legislation that applies in New South Wales, Victoria, and Western Australia. There is also owner-driver legislation in Queensland. It commenced only this month. It had been delayed for some years, but there's possibly a question mark over that legislation simply because we've had a recent change of government in Queensland, and it may be that the new government might look to repeal those existing laws. So that again is a watch this space area. Now, I know that was an awful lot to go through and an awful lot to take in one session. Again, I'd remind you the Fair Work Ombudsman has great resources on their website. The Fair Work Commission has a lot of resources, and also NatRoad itself for members has a lot of resources available to help you navigate these really complicated areas of the new laws. I said originally that I would take about 50 minutes to do this, so I'm a tiny bit under time, and I'm very happy to take questions if there are any, Michelle.
Hi, Gillian. Thank you for that. No, we don't have any questions at the moment, but if anybody thinks of anything after, please send it to info@natroad.com.au and we can pass it on to Gillian. This webinar will also be on the website in a day or so if you would like to watch it again if you've missed anything. So thank you again, Gillian, for presenting today. Have a great day.
Thank you so much, and thank you, everyone.